Right now, in 2026, millions of older Americans are hearing the exact same message from nursing facility intake staff or well-intentioned family members. Drain your savings account. Purchase things you have no real use for. Let the money vanish into monthly care costs. What nobody mentions is that they never had to do any of that. If you are 65 or older and you have more than $2,000 in any bank account, Medicaid will not contribute a single dollar toward your nursing facility bill, not $20,000 worth of coverage, not $10,000 worth, $2,000. That is the actual asset threshold applied in most states as of 2026. But here's the part that almost no one shares with seniors, and that most general financial professionals consistently get wrong. There are 3 specific account types where that very same money becomes completely invisible to Medicaid, not partially shielded, not shielded after you wait 5 years. Permanently invisible starting the moment each one is properly established. Account number 1 can eliminate thousands of dollars from your countable asset total by tomorrow morning, with absolutely no waiting period required. Account number 2 can absorb $100,000 or more, far beyond anything a standard funeral trust could ever accommodate. And account number 3, the one almost no one requests by its correct legal name, can permanently shield an entire 6-figure retirement account with a single phone call in the states where it is permitted. By the time this video ends, you will know exactly what each of these 3 accounts is called, exactly how much money can legally be placed into each one, and the precise steps required to establish each one correctly before you ever sit across the table from a Medicaid caseworker. This matters because of the way Medicaid actually functions when it comes to long-term care. Nursing home costs now exceed $9,000 per month on average across most states. Medicaid is the program designed to cover that expense, but only after your countable assets have been reduced to at or near $2,000. The 3 accounts covered in this video do not lower that $2,000 threshold. What they do is change which of your dollars Medicaid is legally permitted to count toward it in the first place. Before we walk through all 3 accounts, here is why this channel was created. The regulations surrounding exempt Medicaid assets shift by state and by calendar year. Medicaid does not notify you when those rules change. No letter arrives at your front door explaining a new exemption you happen to meet the criteria for. What this channel does is monitor those exact changes on a state-by-state basis and translate them into plain everyday language, specifically for the situations you may currently be dealing with. People who subscribe learn about these changes before they ever submit a Medicaid application. People who do not subscribe tend to discover them afterward, sitting in front of a caseworker who is explaining for the first time a rule that could have preserved their savings months before the application was ever filed. Hit subscribe, enable notifications, and let's walk through all 3 accounts, beginning with the one that can be set up the fastest. Number 1 is the irrevocable funeral trust. In practical terms, this is money you deposit into a trust administered through a funeral home, designated to cover your burial and funeral costs at the time of your passing. The moment that trust becomes irrevocable, meaning you are legally prohibited from canceling it or reclaiming the funds for any reason whatsoever, Medicaid stops counting it among your assets starting on the day you sign the paperwork. Most states set the exempt dollar cap somewhere between $10,000 and $15,000, though several states permit higher amounts, and a handful of states allow unlimited funding through a properly structured pre-need funeral contract instead. What catches most people off guard is how fundamentally different this is from simply opening a dedicated savings account and labeling it for funeral expenses. A standard savings account, even one you have mentally set aside exclusively for burial costs, is still fully counted as your asset because you retain the legal ability to withdraw and spend that money on absolutely anything at any time. Only an irrevocable trust or irrevocable contract, one you are legally prevented from accessing again, causes those funds to disappear entirely from Medicaid's asset calculation. Consider a 78-year-old widow who has $9,000 sitting in a standard savings account. That balance puts her $7,000 above her state's Medicaid asset limit. She believes her only realistic options are transferring the money to her daughter and waiting 5 years or spending it down on purchases she does not genuinely need. Instead, she walks into a funeral home, signs an irrevocable pre-need contract for that precise amount, and by the following morning her countable assets register at 0. She qualifies for Medicaid immediately, and her funeral, which would have consumed that same money at some point regardless, is already completely paid for in advance. An irrevocable funeral trust can typically cover the casket or urn, embalming services, the funeral home's professional service fees, the burial plot, transportation arrangements, and the headstone, all documented in writing ahead of time. Many states specifically require this itemized documentation, commonly referred to as a goods and services statement, to verify that the dollar amount genuinely corresponds to actual funeral expenses rather than representing an attempt to simply shelter cash from the asset calculation. This arrangement is legally classified as a purchase, not a gift. And that precise distinction is the reason Medicaid permits it without activating the 5-year look-back period, the way a direct cash gift to a family member would. The specific action step here is straightforward. Ask the funeral home explicitly for an irrevocable funeral trust or an irrevocable pre-need contract, not a revocable plan, because the exact language on that paperwork is what determines whether Medicaid actually grants the exemption. Request the written goods and services statement that clearly itemizes every cost the funds are designated to cover. Then verify your specific state's dollar cap with your state Medicaid office or a certified Medicaid planner before signing anything, because that cap and whether your state even permits this particular structure varies from one state to the next. The financial consequence in real terms is straightforward. The average funeral in the United States now exceeds $8,000. That money was going to be spent eventually, either by you or by the family members you leave behind. The only genuine question is whether it gets spent in a way that simultaneously makes you Medicaid eligible on that same day, or whether it sits untouched in a savings account, quietly disqualifying you for months while your family struggles to understand why your application keeps getting rejected. That first account addresses the problem of being a few $1,000s above the limit. But what happens when the surplus is dramatically larger than that? If you scrolled ahead searching for the highest dollar figure on this list, go back now, because account number 2 addresses an entirely different problem than account number 1, and account number 3 addresses a problem that neither of the first two can resolve. Number 2 is the Medicaid compliant annuity. This one exists to solve a completely different challenge. Some seniors are not $9,000 above the asset limit. They are sitting on $40,000, $60,000, or $100,000 held in a certificate of deposit, a savings account, or a brokerage account. An irrevocable funeral trust will never be capable of absorbing that volume of money. A Medicaid-compliant annuity can. Here is precisely how the mechanism works. You take a lump sum of cash and exchange it in its entirety for an insurance contract that returns the money to you through fixed equal monthly payments. To be recognized as Medicaid compliant, the annuity must satisfy 4 specific conditions. It must be irrevocable. It cannot be transferred, sold, or assigned to any other individual. It must distribute payments within a time frame matching your own life expectancy, calculated using Social Security's official actuarial tables, not an extended period selected by an insurance company motivated to sell a larger product. And the state Medicaid agency must be named as the beneficiary to collect any remaining payments if you pass away before the contract is fully paid out. Because you are receiving the complete value back through guaranteed monthly income, none of this qualifies as a gift, which means it does not activate Medicaid's 5-year look-back penalty the way transferring that same $100,000 directly to your children would. Almost no one requests this product by its specific name because the majority of insurance professionals who sell annuities have genuinely never structured one that satisfies Medicaid's compliance requirements. They sell a conventional annuity that remains revocable or one that spreads payments across 20 years rather than aligning with your actual life expectancy, and it ends up being counted against the asset limit regardless. That single well-intentioned mistake has disqualified people who walked away from that appointment believing they had already resolved the issue entirely. This account type carries even greater significance for married couples. When one spouse moves into a nursing home while the other remains at home, an annuity purchased in the name of the healthy spouse can convert surplus joint savings into a protected monthly income stream that spouse simply receives each month. Specifically, in most states as of 2026, a non-applicant spouse is already permitted to retain up to $162,660 in assets under the provision known as the Community Spouse Resource Allowance. An annuity can help convert savings exceeding even that protected ceiling into monthly income the healthy spouse keeps indefinitely. Imagine a retired postal worker with $40,000 sitting inside a certificate of deposit, placing him $50,000 above his state's asset limit as a result. He believes his only realistic option is gifting that money to his adult children and enduring a 5-year wait or spending it on home improvements he does not currently need. A Medicaid-compliant annuity converts that exact $40,000 into a recurring monthly payment instead. And the lump sum itself stops registering as a countable asset the same week he submits his application, not 5 years down the road. The specific action step is to contact a certified Medicaid planner or an elder law attorney and ask explicitly for a Medicaid-compliant annuity that is irrevocable, non-assignable, and actuarially sound, with the state designated as the remainder beneficiary. Do not walk into a general insurance office and simply request an annuity. The precise language contained in that contract carries more weight than nearly anything else discussed throughout this entire video. The real financial consequence is this: the monthly payment generated by the annuity will be counted toward your income limit, so this is not money sitting freely on the sidelines. But the lump sum itself, the exact portion that was preventing your Medicaid approval from moving forward, stops being an obstacle on the day the annuity contract is executed rather than 5 years from that moment. Stay through the third account. It has the potential to take a 6-figure retirement account that most families are firmly told must be spent all the way down to nearly nothing and protect it permanently through a single phone call in the right state. Number 3 is a retirement account placed into payout status. Specifically, this applies to a traditional IRA, a 401k, a 403b, or a comparable employer-sponsored retirement account in a meaningful number of states, including Florida, Georgia, and New York. Once that account begins distributing regular monthly payments, the total balance inside the account stops being counted as a Medicaid asset altogether. Only the monthly distribution counts as income from that point forward. In other states such as Arizona, Missouri, and Pennsylvania, the full account balance continues to count even after distributions have begun, which means this particular strategy simply does not apply everywhere, and confirming your own state's specific rule before relying on it is absolutely essential. What most people never realize is that no federal rule governs this at all. Every state made its own independent determination about how to handle it, which is precisely why a financial professional operating in one state can be thoroughly and confidently incorrect about how this works in a different state. Almost no one at the bank or the retirement plan administrator's office volunteers this information because retirement account regulations and Medicaid eligibility rules are written and enforced by entirely separate departments that almost never communicate with one another. Federal tax law already requires most account holders to begin taking required minimum distributions from a traditional IRA or 401k beginning at age 73. In states that recognize payout status, you are not required to wait until 73 to apply this strategy. You can initiate distributions years in advance, specifically to become Medicaid eligible sooner, as long as the distribution amount satisfies your particular state's precise definition of payout status. One critical exception worth noting here specifically: a Roth IRA does not carry required minimum distributions at any age, which means it generally cannot be transitioned into payout status in the same manner. And in most states, a Roth IRA will still be counted as a full asset regardless of what you do with it. Picture a 71-year-old retired school teacher living in Tampa with $180,000 sitting inside a 401k she rolled over many years ago. On paper, that account balance alone disqualifies her entirely from Florida Medicaid. She calls the plan administrator and arranges a single recurring monthly distribution. From that precise moment forward, that same $180,000 stops registering as her asset permanently, while she continues holding every single dollar of it, still invested, still growing, still entirely hers. The specific action step is to call your plan administrator, the actual financial institution holding your IRA or 401k, and ask them directly to establish a recurring monthly distribution at a minimum equal to what your state's required minimum distribution rules specify. Then contact your state Medicaid office or a certified Medicaid planner and confirm explicitly by name that your state exempts retirement accounts once they have entered payout status, because approximately half of all states do not offer this exemption. Assuming yours does without independently verifying it is the single most frequent error families make when attempting to use this particular strategy. The real financial impact here is the most significant of all three accounts. When executed correctly in a state that permits it, this approach shields an entire six-figure retirement account from being depleted to $2,000 before Medicaid coverage ever begins, while simultaneously allowing that account and all of its continued growth to remain completely and permanently yours. Here is what unites all three of these accounts, and this point matters specifically. None of them are loopholes. None of them are temporary workarounds waiting to be eliminated. They are written directly into Medicaid's own official rulebook in nearly every state, in precisely the same way your primary residence is exempt or the vehicle parked in your driveway is exempt. This is genuinely distinct from a Medicaid asset protection trust, which can also shield assets on a permanent basis, but only when it has been established a full 5 years before care is actually needed, because transferring assets into that kind of trust does trigger the look-back period. These three accounts function because they represent either a purchase, an exchange for equivalent value, or a recognized account classification, not a transfer of ownership without compensation, which is the precise legal distinction Medicaid is concerned with. A Medicaid caseworker's actual professional responsibility is to determine whether you currently qualify based on the rules in effect on the date you submit your application, walking you through every legitimate method available to restructure your assets before that date falls completely outside the boundaries of their role. And most caseworkers will acknowledge that directly if you ask them. That is the exact gap this video was designed to address. To summarize specifically what was covered, an irrevocable funeral trust removes thousands of dollars from your countable asset total on the same day you sign the contract, with no waiting period of any kind. A Medicaid-compliant annuity converts a lump sum too substantial for a funeral trust into a protected monthly income stream that does not activate the 5-year penalty. A retirement account placed into payout status can, in the right state, permanently protect an entire six-figure balance with a single phone call to your plan administrator. Share this video with anyone you know who is supporting an aging parent and has already been flatly instructed to spend that parent's life savings down to $2,000 before Medicaid will cover a single dollar of care. One informed conversation before that spend down actually takes place rather than after it is complete can mean the difference between preserving real money and losing it forever. Subscribe, share this with that specific person today, and I will see you in the next video.